Can we see the results of the poll? Right. So as you can see on your screen, 68% of the participants, who are 261, believe that it is important to hold AGMs so that we communicate important matters to the shareholders. 50% of us believe that it is to comply with legal requirements. 49% say it is for decision making. 20% say to meet our shareholders. And only 3% of us say to socialize and to receive gifts. So during the next AGM, because it's only 3 of us say that we want to socialize and receive gifts, there will be no umbrellas because it is being held for basically the 4 reasons up there. 68% communicate important matters, 50% complying with legal requirements, 49% for decision. I think those are the key reasons why we hold AGMs. Right, now moving on to the topic of the day. And you will of course know that following the outbreak of COVID-19, the government has issued a number of directives pursuant to the provisions of the Public Health Act. And these directives are aimed, of course, at curbing the spread of COVID-19. And some of the directives, of course, include social distancing, or some people prefer to call it physical distancing. And these outlaw large gatherings. Now, however, when you look at these directives, they have obviously impacted the ability of companies to convene annual general meetings or even any other meetings in the usual manner. And so the aim of this webinar, therefore, is to sort of share ideas and provide some guidance on the legal provisions in relation to convening and conducting of AGMs and possible options available to companies. And so I would like to start off by looking at the legal provisions, particularly in the Companies Act 2015. Now, when you look at Section 275A(1) of the Companies Act 2015, it requires that all companies, except single shareholder companies, must hold annual general meetings. So all companies, you are a single shareholder company required to hold an AGM. Now, the time by when a company should hold its AGM is determined by reference to the accounting reference date. And when you look at the Act, Companies Act 2015, the directors of the company are required to ensure that the first accounting reference period is within a period of at least 6 months after the date of its incorporation, but not more than 18 months after that date. And when we talk about subsequent accounting periods, again, according to the Act, these are determined by reference to successive periods of 12 months after that, after the first accounting period. Now, again, when you look at Section 310 of the Companies Act, all public companies are required to hold annual general meetings within 6 months of their year end. So if your year end is 31st of December, it follows therefore that by the end of June of the following year, you must have held your annual general meeting. And so my question, and I can see that somebody is already at that question, is what are penalties for not holding an AGM under the Act? Can I just get some reactions from the members? If you just raise your hand, CS Nyaega will see you and will be able to unmute you so that you can respond to that question. What are the penalties for not holding an AGM? Any participant can raise their hand and be able to respond to that question. So if you go to the right-hand side of your screen, you will see invite, mute me, raise hand. If you raise your hand, CS Nyaega will see you and he will unmute you and allow you to respond to that question. So what are the penalties for not holding an AGM? Can I hear some reactions? No reactions yet? CS Nyaega, can you see anyone with their raised hand?
Yeah, we are trying to unmute most of them so they can actually just be able to.
So just pick on any of them and they can respond. The first one who put up their response to that question, please.
I can see CS Samson Kibi.
CS Samson Kibi, what are the penalties for not holding an AGM under the Act?
Thank you, FCS Catherine Musakali. It's a very good opportunity to link up and discuss this topic. I think, can I be heard?
Yes, you can. We can hear you. Thank you.
Thank you very much. I think one of the penalties for not holding an AGM is that the company could actually face the risk of being closed down for non-compliance.
Okay. Thank you very much. One more reaction. FCS, CS Nyaega, sorry. I think you need to become an FCS very soon.
Thank you for that. I've unmuted also FCS Were. FCS Were, you're free to give your response.
Okay, let's just proceed then. When you look at the Act, the Act provides that a company, its officers and directors commit an offense if they fail to hold an AGM, and they will be liable to a fine not exceeding 100,000 shillings. But in the case of public companies, the company itself, each director and officer of the company is liable to a fine not exceeding 1 million Kenya shillings. I want to repeat, 1 million Kenya shillings. And once you have been found liable and you still fail to hold or to convene the AGM, each day that passes is considered a new offense with a fine of Kenya shillings 100,000 each for each day. 100,000 for each director, for each officer of the company that the AGM is not held. So assume that you did not hold it as at end of June. So you are asked to pay the 1 million shillings. You pay the 1 million shillings, but you still don't hold the annual general meeting. Each day that passes is considered a new offense, and you are then liable to pay 100,000 for each of those days. So this therefore means that boards are under an obligation to convene AGMs in the manner that the Act requires us to. So let's look at the acceptable ways of holding AGMs. And one of the acceptable ways of holding AGMs is the old and tried physical meetings of shareholders. The second, of course, is circular resolutions if provided under the Articles of Association. And then, of course, virtual meetings. So allow me to just look at each of those options, and then we'll look at why it is not possible or why it is possible under the Act. Let me start by looking at the physical meetings. When you read the Companies Act 2015, you can actually see that the Act envisages physical meetings as the default position for all companies, and especially the public companies. Now, these physical meetings, however, can only happen if, and we are talking about the COVID-19 era, this can only happen if the number of shareholders physically present are less than the number that the government allows to meet in any one place at the same time. So it means that the number of shareholders and proxy holders at any one time cannot be more than the number allowed by government. And I think it's, I don't know whether it's 15 or 10, I'm not sure anymore, they keep changing. So the COVID-19 pandemic implies that annual general meetings cannot therefore be convened in the usual manner, given the restrictions on large gatherings, particularly for public companies which ordinarily have very many shareholders. So suppose for 1 minute that a company insists on holding an AGM using the old and tried method of physical meetings. How can it do it? The only possible way would be to have the shareholders all issue proxies to a small number of people, maybe the directors, particularly the independent directors, who can then conduct the AGM. However, this option, as you know, our shareholders will not fly, because our shareholders, hundreds of our shareholders, always look forward to these meetings. And therefore, to start telling my mother in the village that she needs to issue her proxy to somebody she doesn't even know is not going to fly. So let's look at circular resolutions, and I'll still come back to how we can hold some of these. When you come to circular resolutions, the Companies Act itself provides that private companies can pass written resolutions pursuant to section 262(4)(a), and that these would have the same effect as though a physical AGM was held. So private companies can pass written resolutions, and the effect of this would be as though a physical AGM was held. What this means is that the board will have to frame the required resolutions, for example, appointing directors, appointing auditors, declaring dividends, so on and so forth, and ensure that these are approved by the shareholders in writing. Obviously, this is not going to be possible for companies with large number of shareholders. It is possible for companies with a manageable number of shareholders, but even private companies that have 50 or so shareholders, this may not be possible. Now, please note the provisions of section 262(2) of the Companies Act. That provision provides that cannot pass written resolutions for specifically 2 matters. And CS Nyaega, I would just like to ask the participants if anybody knows which those 2 are. So you are allowed to pass written resolutions, and it will be assumed that an AGM has been held. But there are 2 specific instances where the Act says you cannot pass resolutions in respect of those 2. Could I please ask any participant to let us know which those 2 are? CS Nyaega, you can pick on anyone.
Right. We have Harriet.
Harriet, please go ahead.
I'm not sure, but I would think it's grave matters like reduction of shares.
Reduction of shares. Any other person? Just one more. Just one more.
We have Jane Kabui.
Jane Kabui, please go ahead. Okay, maybe she's having a problem with her mic. So when you look at the Companies Act, section 262(2), it says you can pass circular resolutions for everything else except to remove a director whose term of office has not come to an end, or to remove an auditor whose term of office has not come to an end. So it means you can still pass resolutions. When it comes to rotation, the usual rotation, you can change the directors. But if my term as a director has not come to an end, you cannot use circular resolutions to remove me. Or if I'm your auditor and my term has not come to an end, you cannot pass a resolution to remove me. So you cannot convene an EGM to remove your auditor whose term of office has not come to an end. Those are the two circumstances where the Act prohibits the passing of circular resolutions. So where circular resolutions can be used by private companies, the members of that company may actually require that the directors frame those resolutions way in advance and circulate to them not just the resolutions only, but a statement explaining what those resolutions are about. Now, the Act goes on to say that where the directors are sharing explanatory statements with regard to those resolutions, those explanations should not exceed 1,000 words. So again, the Act is very specific. Any explanations going out, explaining the written resolutions cannot be more than 1,000 words. Now, the written resolution will lapse on the deadline specified in the resolution. So when you're doing an AGM via circular resolution for private companies, you can state in the resolution that the members must return the resolution by a specific date in time. The Act goes on to say, if you fail to specify in the resolution the deadline by when the resolution should be returned, then the Act says it is 28 days. So 28 days after the circulation of the written resolution, if it has not been returned to you, then it has lapsed. It cannot be voted on after that. When you look at the Act again, it allows the return of written resolutions via electronic means. So the shareholders can vote on the resolutions and return to you via electronic means. Now, a question, when we talk about written resolutions for directors, we always insist that all directors must actually approve the resolution for it to be valid. When it comes to written resolutions of shareholders, must all shareholders approve the resolution? This is a question I would like to pose to the participants. And CS Nyaega, please give an opportunity to anybody whose hand is up. Must the written resolutions be passed by all shareholders? Anyone? CS Nyaega? must all the shareholders approve the written resolutions for them to be valid? Any response? If there is none, let's proceed and say, when you look at section 270C of the Act, it says that the written resolution is passed by the required majority of members. And the required majority of members will be found in your articles of association. So there is no requirement that all the shareholders must approve. Once you reach the required majority of shareholders, it means the resolution has been passed. Now, the Act also seems to suggest that even if a private company's articles of association prohibit the use of written resolutions by shareholders, that provision is void to that extent, which means private companies can go ahead and hold AGMs using written resolutions if it is practical for them. Let me come to the issue of virtual AGMs. Now, when you look at the Companies Act 2015, it is actually silent on the conduct of virtual AGMs. What this means is that the reference should therefore be had to the company's articles of association. This means that the articles of association of a company must expressly permit the conduct of AGMs via either fully virtual AGMs or hybrid AGMs. So if it is not expressly permitted in the articles of association, then a company would not have this option available to them. Now, remember that under Section 142 of the Companies Act, one of the fiduciary duties of the directors is to act within powers, which is according to the power given to the directors under the constitution of the company. And so the directors cannot go outside of the power provided to them under the Articles of Association and convene virtual AGMs if that power is not provided. I do understand that early in April, there was a state corporation that proceeded and held a virtual AGM. But I also understand that when you look at the Articles of Association of that state corporation, virtual AGMs were not provided. Now, again, when you look at the Articles of Association, when you look at the Act under Section 238, any member of the company can bring a derivative claim in respect of any actual or proposed act or omission that involves negligence, default, breach of duty, or breach of trust by any director of the company. So if virtual AGMs are not provided for under Articles of Association, as a director, you're putting yourself in the line of fire if you go ahead and convene AGMs virtually. So where the articles authorize a virtual meeting, you need to look at any restrictions or processes that must be followed for the convening and holding of such an AGM. So the articles will most likely say a virtual AGM can be held, but for it to be valid, you must do 1, 2, 3, 4 things. If the articles set those out, then you must make sure that you follow all those. Now, where allowed, these meetings can be held either fully virtually, which is everybody sits in their houses wherever they are, and you conduct the AGM online, or they can be conducted in a hybrid manner. What that means is that perhaps the chairman The company secretary and perhaps the board can sit in one room, which is considered as the venue of the AGM. And then the other shareholders can dial in, will be given the option to participate remotely, and they will be considered as being part of the quorum for that meeting. So in the cases where the company's articles do not allow for a virtual AGM, my question is, can the company decide to amend its articles to provide for virtual meetings? So assume that your articles do not allow for virtual AGMs. Can you request your shareholders to amend your articles so that you provide for virtual AGMs? And my response is, if it is practical, yes, you can do that. But if it is not practical, then you can't, because you do need the same shareholders to convene in the same manner that they would have convened to hold the AGM, to give you the power to amend the articles. So this cannot be done for like public companies, so on and so forth. So it means that you have to look at other options for helping you to convene these virtual AGMs. So what are the options? Now, for all listed companies, thanks to the proactiveness of the CMA and the order that was issued in a case brought by WPP Scan Group, miscellaneous application number 680, E680 of 2020, and the parties were Bharat Kumartha and the Capital Markets Authority. In that case, the applicant, through their lawyer, Mr. Mwango of Bowmans, moved to court seeking for orders under Section 280 of the Companies Act to be allowed to hold a virtual EGM. In their case, it was not even an AGM, it was an EGM, because they were looking to validate or rather authorize certain transactions. Now, Section 280 of the Companies Act is a section that allows either a member or a director of the company to move to court and to obtain orders that an AGM be held in a certain manner if the usual convening of AGMs is practically not possible. So this is what WPP did. They moved to court and obtained, and they did not actually obtain orders, but they entered into an out-of-court, a consent order with the Capital Markets Authority. And the CMA was actually very proactive and noted that he only entered into a consent order with regard to WPP. They would be opening themselves up to all the listed companies going into court. And it would mean that the CMA is in court literally every day. And so the CMA decided to enter into a consent in this particular case, but used the opportunity to allow all listed companies, whether their articles expressly provide for virtual AGMs or not, to be able to hold their AGMs virtually on condition that the CMA is given satisfactory responses as to how the AGM is going to be held. And the CMA is satisfied that the system that is going to be used is appropriate and therefore gives a no objection. So if a listed company wishes to hold an AGM virtually, all they have to do is make an application to the CMA, and the CMA will give them a no objection based on whether they're satisfied that the process to be used and the system to be used is appropriate. Now, if, however, a listed company does not wish to take this option, are there other options available? So you don't want to do virtual AGMs for one reason or the other. Now, when you look at some of the pronouncements of the CMA in the recent past, they actually give you more options than just the virtual option. So the CMA prepared a circular dated 16th of April 2020 and allowed boards to take certain decisions such as the declaration and payment of dividends pending ratification at the next AGM. So if you take the decision as a board of a listed company, for example, to pay certain dividends, then all you have to do is go ahead and pay those dividends, but then make sure that when you convene the next AGM, then you can have that decision ratified by the shareholders of the company. Now, such a declaration, and let's talk about the dividends. If you do make such a declaration, one of the things that the CMS said is that it is subject to the company's internal approvals and dividend policy. So don't just rush off and declare dividends when those decisions are actually outside of your own internal approvals and dividend policy. They must be within the internal approval, within the internal limits given, and within the provisions of the dividend policy. And of course, that decision has to be subject to submission of the audited financials to the CMA and to the NSC, and as I said earlier, to be ratified at the next AGM. The CMA has also allowed boards to issue and allot shares by way of capitalization of reserves or undistributed dividends, or even scrip dividends to existing shareholders. But again, that is subject to approval by the authority and subject to compliance with the Articles of Association and agreement by the company to hold a general meeting to ratify that decision as soon as the government lifts the current measures, the current regulations on convening of meetings. Now, the CMA has also gone ahead and approved that directors retiring by rotation and those who would be offering themselves for re-election can go ahead and serve. Of course, subject again to ratification at the next general meeting. Now, where they are not to be re-elected, so where a director is not to be re-elected, it does not mean that they should continue serving and assume that the CMA has given them power to a renewed term. What the CMA has said is that in those circumstances, the board still has the power to fill casual vacancies, which would then be subject to the AGM decisions when an AGM can be held. Also, the CMA has allowed boards to appoint auditors until the next possible AGM. So again, you don't have to hold an AGM if all you are seeking for is distribution of dividends, directors rotation, and appointment of auditors. You can do this. The board has now power for the listed companies. The board can do that and have those decisions ratified at the next AGM. So in a nutshell, listed companies are in a good position with regard to the possibilities of holding AGMs or taking decisions that would ordinarily be taken during AGMs. And in this regard, my view is that the CMA has been very supportive and forward-looking in terms of just supporting listed companies to continue operating in this regard. Now, when approving the mode of conducting virtual AGMs, some of the things that the CMA will be concerned with, of course, will be compliance with the law. How are you complying with the law in the issuance of notices, so on and so forth? How are you ensuring that as many as possible of the shareholders are able to attend? How are you ensuring that you protect the minority shareholders? And of course, how effectively can the majority of the shareholders participate during the AGM? And so when you look at the notice that should be issued for a virtual AGM, you must actually state in the notice that the AGM, first and foremost, that this is an AGM and that the AGM is going to be held virtually. And when you look at the Companies Act, failure to state that this is an AGM in the AGM notice attracts a fine of 500,000. Now, under the articles, members, under the Companies Act, members have power to request that proposed resolutions be circulated in advance, even for AGMs, and this will have to be mandatory. But care should be taken when you're issuing the notice to include more information than you would ordinarily include in a notice. So, for example, details of the virtual meeting, your registration link for shareholders wanting to register for the meeting. Please keep in mind that you need to amend the notes that normally go out with the AGM notice at the bottom there, talking about proxies, talking about where the proxy is to be delivered, the periods within the proxy being delivered, so on and so forth. So just take special care to make sure that those notes are appropriate, and also make sure that the service provider you choose for hosting the virtual AGM will go out of their way to educate as many of the shareholders as possible so that they can participate in the AGM. So what about other public and private companies which are not listed and which are not able to hold the AGMs in the usual manner for one reason or the other? And also those that cannot pass circular resolutions, which we talked about, or those that are not able to hold virtual AGMs because their articles do not provide for this. Now, when you look at the Companies Act, it provides for other options for these companies, and I want to focus on these options very, very quickly. The first option, of course, would be to apply to the Registrar of Companies to postpone the AGM. That is a power that the Registrar of Companies has. And when you look at the Act, it is possible to do this. The second option is to amend. Remember that the AGMs are held with reference to the accounting reference date. So you can actually amend your accounting reference date so that it is at a later date. You can also make an application under Section 280 of the Companies Act so that you can, the court can order for you to hold a virtual AGMs. You can use proxies, and of course, lastly, you can also convene and then adjourn an AGM immediately. Let me speak very, very quickly about each of these options. Now, when you look at Section 275A(3) of the Companies Act, once you submit an application to the Registrar of Companies, the registrar can extend the period by when an AGM should be held, and the wording of the suggestion of the section actually suggests that you could get an approval to hold your AGM next year. Now, companies can also make an application to the Registrar of Companies to change the company's accounting reference date by extending the same, and the impact of this application would be to extend the period within which an annual general meeting can be held. With regard to this, however, that extension cannot be for longer than 18 months. And this option is only available once every 5 years. So if you have already changed your accounting reference date within the last 5 years, you cannot do it again. The third option, of course, is similar to the application under Section 280 of the Companies Act, as was the case for WPP Scan Group. And the fourth option is to simply have shareholders issue proxies to a small number of people or directors who can then convene and conduct the AGM. The fifth option, which I don't recommend, is you convene the AGM in the usual manner and on the usual date. Make sure you have a quorum, and then immediately you adjourn that AGM to a later date. My view is that this may not help you, because you may find that you're still running out of time within which to hold the AGM by the time, as the pandemic goes on. So before I end, let me say that if you're planning to hold a virtual AGM, please make sure that you start discussions with your service provider early enough, because there's quite a lot to be done. Make sure that the system they will be using has the capacity and capability to simulate as much as possible the physical AGM. So how can shareholders interact with the board during the AGM? How can they take decisions? How can they vote? How can they poll if they're going to have to use a poll, so on and so forth. But also, as we move on, I think the pandemic has given us time to relook at the way we conduct our businesses. And there are very many advantages for holding virtual AGMs. And some of these, for example, include an increased number of shareholder participation. There is a limited number of shareholders who come for AGMs, but when you hold a virtual AGM, you actually give an opportunity to more directors, more shareholders to hold those AGMs than would usually be the case. These virtual AGMs are also cost effective in the long run, not just for the company, but also for the individual shareholders. My mother would not have to travel all the way from Kakamega to come and attend an AGM of 2 hours and then travel back. She can do that from the comfort of her house. And then in a physical AGM, the board does not necessarily respond to all the questions. Neither does the board give an opportunity to every shareholder to ask a question. With the functionality of virtual AGMs, the board has a record of all the questions which have been asked online, and the board can actually respond to them very, very quickly, or even at a later date and post the responses on their website. So let me stop there for now and allow some interactions. I hope that I've given you some food for thought, and I hope that you have found the session useful. Thank you very much.
Thank you very much, FCS. Catherine, please feel free to clap for her on online. We'll be able to see your claps and appreciate them. I want to call upon the technical team that has been summarizing the questions. That is CS Karanja. Please be ready to look at the questions that the panelists have been asking and then see which ones have all been addressed. Then you can probably in one go give a summary of the questions that FCS may address. So CS Karanja, are you ready to give the summary of the questions not responded to? So CS Karanja, we are waiting for you to give the summary. You ready with the summaries of the questions?
Thank you. Thank you, CEO. There are a number of questions, and if I don't mention yours, just know it's because it had already been addressed. So one there is a question on the issue of NGOs. So yes, Catherine, you are requested to address AGMs for NGOs. I combined that with another one for professional bodies. And in particular, where you mentioned that if the articles do not allow for virtual AGM, what happens to professional bodies and NGOs where their constitutive documents do not allow for that? Then there was also a question on what are some of the service providers that you would recommend in holding such AGM? And lastly, the issue of security in regard to the online platforms that are used in holding such AGM and other governance risks that are involved. How do you deal with that? And then maybe the final one is in regard to polling, elections and whatever else that requires members to poll during an AGM. How do you deal with that? Thank you. The rest of the questions, I think they have fairly been addressed during presentation.
So thank you very much. We welcome back FCS Musakali to respond to those questions as we wind up. I will request for your patience for a few more minutes, then we can close out. FCS.
All right. Thank you very much. NGOs for, AGMs for NGOs and professional bodies. And the question would have to be, what does the constitution of the NGO say with regard to holding of the AGMs, and what does the NGO Act say? Yeah, so you'd have to go back to the NGO Act, and you'd have to go back to the constitution of the NGO. But you also have to ask, because I know that there are some NGOs which are still incorporated under the Companies Act, yeah? You would have to ask, if they are incorporated under the Companies Act, then you'd have to make sure that you comply with some of the issues that I've talked about. However, reference would have to be to the NGO Act as well as the constitution of the NGO. Now, I know that there's some confusion around which NGO Act is applicable. And there is the NGO Act of 1995, I think, 1991 or 1995. I'm trying to remember it. I think it's 95. But then there is the NGO Act of 2000 and is it 15? And there has been some argument around which act is applicable. And the guidance I have from the NGO Act, from the NGO sector, is that the earlier act is still in place. So please have reference to that. With regard to professional bodies, of course, you'd have to look at the act setting up the professional body, and you'd also have to look at any other guidance with regard to professional bodies. I don't think we have such a problem, because most of your professionals are easily, are people you can reach very easily, and they are people who can pass resolutions, so on and so forth. The key thing is whatever you do has to be within the legal mandate that you have been given. It has to be viable, and it has to give an opportunity for most of your members to be able to participate. So in my view, professional bodies are in a position where it is quite possible to hold even virtual AGMs without doing too much. And many of the acts setting up these professional bodies may not actually talk about virtual AGMs, but within your own rules, you can actually put in place something that allows you to hold virtual AGMs. I was asked, what are some of the service providers you would recommend? I don't want to recommend any service providers. The only guidance I can give is that most of the registrars available in the company have systems that are able to support virtual AGMs. And I don't want to name them because if I do name them, I might be accused of promoting some of them. But the guidance I want to give you is, please check out who the registrars are, reach out to them and ask them whether they have a virtual system that they can use for AGMs. Now, when you look at the order obtained in the WPP case, you will find that they used, I think, a very simple, they are proposing to use a very simple system. They have asked shareholders to dial a Safaricom number or to dial a Telcom number. And so these platforms are worth checking out to see how viable they are for you. Please keep in mind the size of, or rather the number of shareholders you have, because some platforms may be able to support a certain number of shareholders while others cannot support that. So keep in mind how many shareholders you have, and therefore choose the platform that most likely will reach out to as many shareholders as possible. Security for online platforms and other governance risks. Yes, this is something that you must discuss in detail with your service provider. For example, when you give them sign-in details, and I am one shareholder, can I share those sign-in details with 5 other shareholders who will vote at the same time with me? So you have to get assurance from the service provider that, for example, sign-in details are only one use. So you cannot use the same sign-in details by 10 other shareholders. So the service provider is responsible for the security of the system, and you as a company secretary must ensure, and you must be happy that they have taken into consideration all the security instances and they have taken care of them. Key among them, of course, is that voting. How do you assure yourself that it is only your shareholders who are voting and not others? And I think it is important to ensure that as many of your shareholders as possible are able to access. Elections and polling, how do you do this? How do you deal with this? Very, very simple. If you look at our system today, even as simple as Zoom or WebEx or Blue Jeans or these other systems that are available, you're able to vote. At the beginning of this session, I asked you to take a poll, and you are able to poll. So you can imagine a system that has been specifically developed for AGMs. It will give you the opportunity to poll, and the beauty is that the results can be instant, and they can be shared instantly with the shareholders. So polling, voting on issues, so on and so forth, the systems that I have seen, because I have had the opportunity to sit through the demonstration of one system, and I'm quite satisfied that that system gives the opportunity, one, for any shareholder to ask any question, to vote on any manner, and to be able to participate fully and effectively in any AGM. It has the capability of video as well as audio, and therefore, as much as possible, other than the fact that you're sitting in your house, you actually fully participate in the decisions of the AGM. Thank you.
Thank you very much, FCS. We really appreciate. As we come down, I'm still seeing very many hands being raised. I want to request that you post your question on the Q&A module on your on the platform that we are using. We will be continue collecting the responses that we receive, and then we'll be able to also share this recording on our online platforms, including our all the channels that including our website. And just before we leave, I would request that the council chair, FCS Waweru Madenge, who is present, he could kindly just give a word to the members, then we could finish it up. So I want to invite the council chair, FCS Waweru Madenge. You can hear me, kindly proceed.
Yes, before FCS Matenge comes, let me just say one thing. If you get the opportunity to hold a virtual AGM and you are coming from a listed company, you're coming from a private company, please use that opportunity to amend your articles of association, because this may not be the only time you want to use that opportunity. So the first opportunity you have to amend your articles of association to provide for virtual AGMs, please do that. Thank you.
All right, thank you. FCS Waweru Madenge, Chairman.
Thank you. Good afternoon, all. I hope you can all hear me.
Yes, we can.
Very good. I don't think you can see me. Maybe CS Abara, you can enable the video, but I'll nevertheless proceed. So thank you very much. I would have taken the opportunity to welcome you to the first live webinar hosted by the Institute. But let me just take this opportunity, since we have already gone through it, to thank you very much for having attended this first live webinar of the Institute of Certified Secretaries. As the Institute, we are alive to the challenges that we are facing as a country, as a globe actually, with this COVID challenge. And as the saying goes, necessity is a mother of invention. It has caused us to look at various ways or alternative ways of how we can continue doing our business without interruption, but at the same time, trying to be faithful to the governance principles that we as professionals have been called upon to uphold. So this is just an example of one of the innovative ways that your council has decided to respond to the challenge, having this webinar. And the topic of this particular webinar couldn't have come at a better time. And we had a great presenter in FCS, Catherine Musakali, to give us that presentation. And thank you very much for that very enlightening and informative presentation. I'm sure a lot of us had a lot of questions on how to go about holding the AGMs, and a lot of clarity has been provided with that. Your council will continue to look for more other innovations that we can use, not only to impart the knowledge and provide this opportunity for learning and training, but also for our own governance structures. I'm happy to say that we have been holding council meetings via this technology that is availed, that is Zoom, among others. And we are looking into how we can hold our own annual general meeting using the technology that is now available, and just trying to see that we do it in a way that meets all legal requirements. We call upon you, members of the Institute, to continue to engage us, communicate your views on various issues and regarding our profession and the work that we are doing as your council. On the programs for learning and development for the CPDs, we call upon you to give us your suggestions on topics of interest that we can cover. In addition, we also call upon you to do research, to present articles which can then be published in our governance journal. We are looking to publish the governance journal. We just approved the publication of the first governance journal at our latest council meeting about 2 weeks ago. And we shall be looking to have this as a quarterly publication. So we are calling upon you all to present articles, well-researched articles on areas of governance so that we can broaden and enhance knowledge in this particular area. With that, I just want to once again acknowledge your presence in this webinar and your very active participation. And we look forward to further engagements of this nature in the near future. I wish you all a great afternoon, and as we has become the new greeting or goodbye, so I wish you, or rather I ask you to keep safe, and have a great afternoon. Over to you, CEO.
Thank you very much, Chairman. As Chairman has mentioned, so we have very many CPDs. You can check on our website, www.ics.ke. Many things lined up. The governance journal will be shared. Look out and we share knowledge. On behalf of the council, the PDC and Secretariat, I want to wish FCS Musakali. I want to thank FCS Musakali for the presentation, and all participants, thank you very much for your participation. I also want to thank the Secretariat, Head of Professional Standards, CS Karanja, Julius, and the Secretariat for your support. Thank you very much for all that you have done. We look forward for your continued support, and we shall finish as we started with our national prayer. And therefore, for those whose mics can be unmuted, we will do the same way our prayer in national anthem as we stick together, keeping safe and knowing that this pandemic shall end and we shall emerge stronger and more innovative. Thank you. God bless you. Ee Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. Thank you very much. We will keep this page open a bit for those who may want to give more comments for a while until we get as much as we can, then we shall close it up. Thank you and enjoy your afternoon.